Still says going live. Going live. Am I live? Am I live? Oh, God, I'm a boomer. Okay, I'm just going to assume I'm live. And I'm going to go. All right, so for those of you who aren't aware, I did a video a couple days ago on qualified immunity. And I had the position that qualified immunity is not necessarily a bad thing. It's not necessarily a bad thing because at the end of the day, with qualified immunity, it tends to get rid of the bad causes of actions. And it frees up space in the courts for good causes of actions. So I'm going to try to go through this case. Several people had posted this particular case to me as evidence of qualified immunity being broken. This particular case went all the way up. They petitioned the Supreme Court for writ of certiorari. The Supreme Court rejected it. It's got a lot of attention, and like I said, it popped up several times in my comment section. So I figure we'd go through it together and hopefully try to make sense of why this is not the terrible abuse of law or a complete failure of qualified immunity that people think that it is. So let's start off with some background facts. This is the original complaint. I spent a crap ton of money on Pacer to download just about all of the documents that I think we would need. And I have most of them up here. We're going to go through most of them quickly. I don't hope this won't take much longer than about half hour. Unless I get some good questions from people, it should take a half hour or less. So let's go with some of the facts that happened in this case. Derek Kumagi is one of the defendants. He was a detective for the city of Fresno. He had reason to believe that the two plaintiffs, Jessop and Ashtian, were operating what are called coin push or coin pusher devices. These are games of chance, essentially, where the most fundamental form of these particular games is you drop a coin in and it lands on a little ledge where there are other coins. And you hope you knock a bunch of coins off. And more often than not, fewer coins, it takes you more coins to knock coins off than you get back. So the house wins. That's the point of one of these coin push machines. And in the state of California, these machines are illegal. It's a misdemeanor to operate them. And Lyncher is asking something entirely off topic. Thank you, Lyncher. I'm going to ignore off topic for now. So he started an investigation. Jessop and Ashtian also operated ATM machines in stores. So they had ATM machines and these coin push machines operated in stores throughout Fresno. Derek Kumagai was a detective. He got a search warrant with a seizure provision in it. It was signed by a judge that they could seize coin push machines as well as monies, currency, coins, etc., that were either obtained through the use of these coin push machines or used for these coin push machines or laundered from these coin push machines, etc. So he got a valid court order. This is undisputed, a valid warrant. It's undisputed that Derek Kumagai got a valid warrant. He served the warrant with a whole team of people. You can see how many people are on here. All of these are officers. Cantu, Chastain, Dodd, Reynolds, Zarusa, Erlanes, Arayanes, whatever, Garza, Bunch, Fry, and Does 1 through 10. So a whole bunch of cops went and served these warrants in, I believe, 3 physical locations. At these 3 physical locations, plus an automobile that was at one of these locations, they found money. Now, according to their records, they did an accounting, a property inventory of the monies that they took, and they took a little over $50,000 off the property. It's undisputed that they took at least $50,000. According to the police, and this is undisputed, they also initially took coin collections. Some of the coin collections they returned immediately, as in they wrote them on the inventory as though they were going to take them. They determined that these were not, the police officers determined that these were not monies that were obtained through coin push machines, because these are collectible coins. And so they left them in a suitcase on a bed, I believe. And that's undisputed that some were left there. Other coins were returned, like a silver dollar collection, and 10 other boxes of coins were returned, this is undisputed, to the plaintiffs after that. Again, because the police determined that these were not part of the coin push games, the illegal gambling games. The plaintiffs admitted to operating coin push machines. They admitted to it. So that's a done deal. These guys weren't innocent of it. They admitted to it, and they signed a deal with the city of Fresno that they would give the city of Fresno $50,000, the seized $50,000, in exchange for not being prosecuted. In addition, they agreed to act basically as undercover snitches for the city of Fresno. So these guys, I mean, they did commit a crime. I mean, it's undisputed that they committed a crime. It's undisputed that there was a valid search warrant for the seizure of monies. Okay? Now, this seizure happened in 2013. You may be aware that the city of Fresno and all of these police officers are either a government agency or government agency employees. What that means is, in California, they fall under the Governmental Claims Act. California has a Governmental Claims Act. What that means is before you can sue the government or a governmental agency or a employee of a government agency who is acting in their official capacity, before you can sue them, you have to submit your claim to, it depends, either the agency or to the Attorney General, but you have to submit your claim. And then the state of California or that agency, whoever you submit the claim to, will say, okay, we'll pay the claim, or they'll say, no, we reject your claim. And if they reject your claim, you have 6 months to file your claim, your state court case. You have 6 months to file a case. So Jessop and Ashtian, at some point in time, determined that they're missing roughly $130,000 plus, and that's in actual monies, plus what they valued at another $80,000 to I think $100,000 in collectible coins and gold coins that they believe were taken by the police and were not put on the property, the inventory sheet. Now, they submitted a claim. This is, again, undisputed. Jessop and Ashtian submitted a claim to the state of California for these monies. And the state of California rejected it. And the 6-month window lapsed. It was gone. They also, when they had some of their property returned, they had a computer that was broken by the police department. It had fallen off of an evidence cart and was broken. Kumagai, this Derek Kumagai, helped, I believe it was Ashtian, prepare a claim for the computer. That claim was accepted, and I think it was Ashtian. It might have been Jessop. There was a lot of paperwork that I've read. Submitted and was paid $1,000 for this computer. So these are all undisputed facts. So 2 years later, this was filed in 2015. 2 years later, Derek Kumagai gets arrested and charged with bribery, accepting bribes. It was, I believe, $120,000 worth of bribes. So in an unrelated case. And the next thing you know, Jessop and Ashton are filing a complaint in federal court for unreasonable search and seizure of property under 1983, 42 U.S.C. 1983, deprivation of property without due process, violation of substantive due process, and municipal liability. This is a Monell claim. And I'm not going to deal with the Monell claim in all of this because remember, the point of this exercise is to determine if this was a huge failure of qualified immunity. So we know it was about a valid search warrant. So how could it be an unreasonable search and seizure of property? The search warrant said they get to take the money. They have a search warrant. Remember, they can't seize anything without probable cause. And they presented to court what a judge determined was probable cause. And a judge signed off on a search warrant. And the search warrant said they got to take all monies and valuables, etc. So was it an unreasonable search and seizure of property under the Fourth Amendment? Probably not. The next question is, were they deprived property without due process? Well, obviously, there was a warrant for the initial seizure of property. That's about as due process as you're entitled to. But then once the property wasn't returned to them, what is their due process? What is their procedural due process? And that procedural due process was to file a claim with the state of California under the Governmental Claims Act. If the government denied it, which the government did, then they would have 6 months to file in state court a tort claim for conversion. Because it's wrong to steal, right? So that is their procedural due process that for some reason they believe they weren't given. Then we have violation of substantive due process. Substantive due process is a strange beast that is really hard to pin down. Substantive due process, you have a right to liberty under the 14th Amendment. So something that takes away your right to liberty might be a substantive due process claim, like a law that says that you can't teach a kid to speak German. There was a Nebraska law about you can't teach kids German. That was struck down under substantive due process because it affected a liberty right. Now, not everything is a liberty right. And the problem with this violation of substantive due process, well, it's twofold. The first one is that there is another constitutional amendment that better fits, and that would be the Fourth Amendment reasonability test. So that's a huge hurdle that they have to overcome in the first place. The second problem that they have is it has to be shocking. It has to shock the conscience, whatever the hell that means, in order to qualify under the 14th Amendment for a substantive due process violation, like not allowing married couples that are mixed race to live together. That shocks the conscience. That's something that would be a substantive due process violation. Somebody's saying that I'm broken. If I'm not coming through, then let me know. Apparently, I'm having mic issues from time to time, so let me know. Anyway, I'm going to proceed on unless I hear back from somebody that I am not coming through. Anyway, to continue. So that's a problem with that one, and I'm not going to go into the Monell claim. So the very first thing that the officers do, well, first thing that happens is they agree to get rid of everybody they get rid of all these guys. So now it's down to the parties agree to it. It's down to the city of Fresno, Kumagai, Cantu, and Chastain. And so the next step is that the defendants file a motion and notice of motion to get summary judgment. So this is the notice of motion and motion. It just says basically that they're entitled to judgment on the first cause of action because there are no materials of fact to support their claim. They're entitled to judgment on the second cause of action because there are no material issues of facts to support the claims. And the third one, again, because there's no material issues of facts to support the claim. And regardless, defendants are entitled to qualified immunity. And they have a memorandum of points and authorities on it. And I don't know how much I'm going to get into this. It basically boils down to what I've already said. The right cause of action for this was possibly conversion. They wouldn't have had the opportunity to get qualified immunity on it. Okay, coming in loud and clear. Good. All right. So the right cause of action would have been conversion. Conversion is basically the tort, the civil claim for theft. That would have been the right cause of action. But again, they couldn't sue for the tort of conversion because that time frame had lapsed. They had 6 months to sue after their claim was rejected, and they didn't do it. So you don't see that cause of action here. And the defendants argue basically what I just said, that the Fourth Amendment doesn't apply to this one, number one, because there are no statements by any of the defendants, any of the plaintiffs, where they saw an officer take it. The defendants or the plaintiff's case boils down to this. After the officers had seized the money, they did an accounting. And they gathered up all the receipts from all their ATM machines. They figured out how much money they had laying around. They checked all their bank accounts, and they came up with an accounting. And according to their accounting, they were short about $131,000, including the 50 plus that it's like 50,000 and change that the officers had seized. So after the officers had seized stuff, they were short $131,000. They didn't see the officers take the extra $131,000. They don't know which of the officers, if any, took it. They just know that before they had $131,000 that they now don't have. Or at least they're alleging that. They did not prove that, but they're alleging that. They're also alleging that they had gold coins and coin collections beyond what were returned, because they do acknowledge that some were returned. But they don't have any verification of the value of those coin collections. They didn't get them appraised. They didn't produce receipts. They just said, yeah, we had these things, and now we don't. Well, that doesn't prove anything. The officers say they didn't take it. Okay. You say you had it, and the officers searched and took stuff, and now you don't have it. But does that mean the officers took it? Say, for example, just to help you kind of wrap your head around this, say, for example, you walked into Walmart and you drop money on the ground, right? Someone comes behind you and picks up the money and says, "Excuse me, sir, you dropped your $5. And you think to yourself, wait a minute, I thought I had more money in my pocket than that. Well, how much did you have? I don't know. I don't know. But I'm pretty sure I had more money than that. Did you have 20s, 50s, hundreds? I don't know, but I think I had about $200 in my pocket. Okay, well, when's the last time you saw it? I don't know. Did you have it when you came into the store? I don't know. But I know that at some time before now, I had $200 and you only handed me $5. So who took the extra $195, and or did that extra $195 exist in the first place? So you see what the defendants or the plaintiffs are up against. They didn't see the officers take anything beyond what the officers said they took. And the officers returned, it's undisputed that the officers returned coin collections. 10 boxes of coin collections beyond what they left at the scene. So that's a real problem for the unreasonable search. Plus, they went in there with a valid search warrant. I mean, that's just a huge thing. The deprivation of property without due process, that is a procedural due process right. We've been over that. We've been over their argument for it. The violation of substantive due process, we've been over the argument for it. And so what the defense does, it's pretty crazy. First thing they do is they actually file every deposition in the case. This was a massive document. I have no idea why they did it. This is not what you do. If you are going to file a deposition, at least in California, what you do is you include the first page, you include the page that has the relevant testimony on it, and you highlight that relevant testimony, because it's not the court's job to read 200 and some odd pages of transcripts of 4 pages per page transcripts, because this is page 32, 34, 33, 35, all on this particular page. So this is a lot of stuff for a court to go through. So I don't know why they did it. And then their argument basically boils down to the wife testifies that she saw Derek Kumagai. They changed their story a little bit from "we don't know who took it" to now she's testifying that Derek Kumagai took her to the bedroom. You know, he had her show her around the place, and when they got to the bedroom, he stopped and said, "Are there any coin push machines on the premises?" And she thought that he was trying to lead her away from the bedroom, but that doesn't establish that he actually went into the bedroom and took anything, or that there was anything in the bedroom to take. She also alleges that while she was in the living room, he went into the back. But she didn't see where he went. She didn't see him take anything. She just said he went back there. She also gave conflicting evidence or conflicting testimony on whether or not Kumagai was the last person to leave, or whether the officers all left together, etc. So they try to throw out what is basically irrelevant information that does not establish a genuine issue of fact. If the wife had come out, well, there's a problem with that too. There is a rule that essentially, if the plaintiff says that nobody saw the defendants do X, he can't then pull a witness later, especially his wife, to come in and say, "Oh, actually, I saw the defendants do X." But beyond that, what they were trying to do is they were trying to, instead of saying "we saw the police officers take X," she was saying "we saw the police officers go someplace and they might have taken X while they were there, and X might have existed while they were back there." So it's an incredibly weak position for the plaintiffs to be in. And the defendants pointed it out. They pointed out all the inconsistencies. They literally went through every response, every single response to these are undisputed material facts. They went through every single one and rebutted the statements that the plaintiffs tried to bring in to bolster their case. And it just was not a very strong case. That's the unfortunate, the long and the short of it. It was not a very strong case. So the court, I thought, did a very well-reasoned ruling on it. Now remember that there were 4 causes of action, and the court only ruled qualified immunity on the first cause of action, the Fourth Amendment seizure cause of action. As far as the procedural due process, number one, the plaintiffs abandoned it. They didn't try to defend it on their opposition to the motion. And number two, the plaintiffs had procedural due process. There was a warrant. There is a cause of action. They go through the tort claim process. There are also, you submit requests to get your property back, et cetera, et cetera. They had procedural due process. As far as a substantive due process, the court found that the Fourth Amendment was the right constitutional provision to proceed under, not the 14th Amendment, which is accurate because they're saying that the police seized this stuff and didn't return it. That was their fundamental argument. So as far as the Fourth Amendment is concerned, the court said that it is not a constitutionally how do I phrase this? As far as the Constitution is concerned, that it is not established that it is a violation of the Fourth Amendment for an officer to take something, pursue it to a valid warrant, and then steal it. Now, everybody's head is going to explode at this point, right? The court isn't saying that it is right for the officer to steal. The court isn't saying that there is no remedy if a cop steals from you. The court is saying that the Constitution doesn't protect against that, or it's not clearly established that the Constitution protects against that particular wrong. Not every wrong is a violation of the Constitution. And this is a particular wrong where, at least according to the court, the Constitution doesn't protect you. The district court mentioned a couple of cases that in other circuits that said one way or the other. One circuit said, if the cop is taking from the evidence locker, then that is not a violation of your constitutional rights. And there's another circuit, the Fourth Circuit, I believe, that said it was, because you are continuing the seizure. That cop is an agent of the government, and he's continuing the seizure. So that's the only one that the court said was qualified immunity. And again, this is a loser case. This is a loser case. The plaintiffs could not prove, in order to prove a 1983 action, they have to prove that a specific cop did X. They can't say that X happened and all these cops were there, and so the cops have to figure out between themselves who did it. They have to prove by a preponderance of the evidence that a specific cop did X, did the wrong. And they did not have any evidence that a specific cop did the wrong. They couldn't show where a cop deposited a bunch of money the next day. I mean, they had nothing. They had no evidence to work from. All they had was, we're alleging that we had this money beforehand and these gold coins. We can't prove that we did, but we're alleging that we did. After the cops left, we didn't have it. Ergo, it must be the cops. That's all they had. And that is not enough to prove by preponderance of the evidence, that's not enough to prove that the cops did it. They have to prove a specific individual cop did X. So again, it's a loser case. Now, stop that. As far as the Ninth Circuit, did two opinions on this one. And the second opinion, you could really see that they listened to the uproar about this. Oh my God, this injustice, right? These people need their day in court. They're saying that the cops stole what amounts to $225,000 or so worth of stuff. They need their day in court. And I thought that the opinion worked rather well. Importantly, we observed that the technical legal question of whether the theft of property covered by the terms of a search warrant and seized pursuant to that warrant violates the Fourth Amendment is a different question from whether theft is morally wrong. We recognize that theft is morally wrong and acknowledge that virtually every human society teaches that theft is generally is morally wrong. That principle does not, however, answer the legal question presented in this case. And they go on to say this, that was a footnote. They go on to say, we've never addressed whether the theft of property covered by the terms of a search warrant and seized pursuant to that warrant violates the Fourth Amendment. The only circuit that has addressed that question, the Fourth Circuit, concluded in an unpublished decision that it does. See Moms Incorporated versus Willman. Moms involved federal agents who failed to return the plaintiff's watch after the execution of a search warrant. Relying on the Supreme Court's decision in United States versus Place, the court reasoned that the Fourth Amendment regulates all interference with an individual's possessory interest in property, not merely the initial acquisition of possession. Thus, because the agent's theft of the watch interfered with the plaintiff's interest in it, such theft violates the 14th Amendment. Although we, the Ninth Circuit, have not addressed this precise question, our decision in Brewer v. Beck is instructive. There, officers impounded the plaintiff's vehicle pursuant to a statute that authorized the seizure of vehicles when the driver had a suspended license. When the plaintiff later appeared at hearing with proof that she was a registered owner of the vehicle and her valid California driver's license, however, the government refused to release the vehicle to her. We reasoned that the Fourth Amendment was implicated by the government's actions because the Fourth Amendment doesn't become irrelevant once the initial seizure has run its course. Because the exigency that justified the seizure of the plaintiff's vehicle vanished once the vehicle arrived in impound and the plaintiff showed up with proof of ownership and a valid driver's license, we held that the government's impoundment of the vehicle constituted a seizure that required compliance with the Fourth Amendment. Blah, blah, blah. Brewer's facts, however, vary in legally significant ways from those in this case. Whereas Brewer concerned the government's impoundment of a vehicle, appellants argue that the city officers stole their property. And while Brewster involved the seizure of property pursuant to an exception to the warrant requirement, the city officer seized appellant's property pursuant to a warrant that authorized the seizure of the items allegedly stolen. Even if the facts and reasoning of Brewster would dictate the outcome of this case, however, it was not clearly established law when the city officers executed the search warrant. The city officers seized appellant's property in 2013. Brewster was not decided until 2017. For that reason, we need not decide whether the city officers violated the Fourth Amendment. Again, they're not saying that the officers can steal from you with impunity. Obviously, there are penal codes against that. Police officers can be arrested for theft. There are civil causes of action as well. Again, it's conversion. The problem, again, for those of you who are late joining, is that by the time they filed this particular case, the statute of limitations had already lapsed for the cause of action for conversion. All right, so I'm going to look through to see if there are any questions that are sufficiently interesting. And I'm not really saying anything so far. The warrant should be the inventory. If not, it is theft. Oh, well, that's excellent reasoning, Mouse. The warrant, as I stated earlier, before you type this, the warrant covered the seizure of all money. All money. So there you go. Can you make claims for intentional torts under California law, though? Yes, you can. Against the government. Yes, you have to go through, because the government is sovereign. You have to go through the California's Governmental Claims Act, which is Code of Civil Procedure 810? 810 to like 900 and something. It's a conversion claim. Yes, it should have been a conversion claim. If this was a car taking possession, is there liability? How does this differ? That's inane. I have no idea. Mouse, you ask the wrong questions. Merb, are you aware that Earl's bond violation hearing ends on the 14th? Yes, I am. California is a nice place to visit. Yeah, it's a great place to live, except for all the stupid laws. Again, Mouse, if they didn't use a search warrant and claim to act lawfully, would that make the official action commandeered property? Like you just throw words out there like just randomly. But Merb, didn't Taylor v. Riojas reaffirm that rights violations don't always have to be clearly established in court? No. What Taylor v. Riojas established was that, it was the Ninth Circuit had already ruled this. Basically, if it is such a clear violation of a constitutional provision that no reasonable person would be able to say this isn't a violation of the constitutional provision, then you don't have to have it established by court, because it is so apparent that any reasonable person would already know. For example, we have a Eighth Amendment restriction against cruel and unusual punishment, and I'm going to say I don't remember who the prisoner was. I think it was Taylor. Whoever the prisoner was in Taylor v. Riojas was tortured for weeks, kept in a cold cell, not given a toilet, so he had to shit on the floor and stand in his shit. I mean, just horribly mistreated, not given clothing. And that is clearly a violation of the Eighth Amendment. So that's, I guess Taylor v. Riojas affirmed it for all the circuits, but the Ninth Circuit already had it. Again, I have no idea what Mouse is trying to talk about. What's the latest on Earl? Not really discussing that right now. Lyncher says, okay. Fascinating, man. Thank you, Nasty Nathaniel. All right. So it looks like we got everything out of the way. This should be available as a video to watch with sound and everything, hopefully. So you can go back to the beginning. If you have any questions, leave them in the comments. Thanks for watching and have a great day.